Mention one group 6 appeal for inclusion in the list.
Inclusions you may give.
Item number 1. For the petition, but here the Public Service Commission is the answering respondent. Perhaps they are not appearing. Sir, they have received.
Who has received with learned advocate?
No, the office itself.
Office has received.
I do
Within
not know who
the
is appearing,
service report?
But I have prepared, but I could not inform it. I have prepared, but I could not inform it.
You have not filed it yet.
No. They have received. The track record shows they have received. And I do not know who usually appears on behalf of the Public Service Commission.
Who?
Pradeep Rai.
There is no order of the tribunal yet.
No, because the tribunal is not functioning. The register date fix the date on the month of June.
So 10 to 25, what is the order of 10 to 25? Which you have impugned before the tribunal.
No.
Yes, 10 to 25 is 80.
Yes, page 80.
Yes.
They passed this order.
You are at which serial?
Both for the 4 petitioners are here.
All are.
All 4. All 4. Only.
So you don't want to be disqualified?
My lord?
You don't want to be disqualified?
No, yes, my lord. According to my, it is only the result of the typewriting test. In the first round and the second round of recruitment process, I was successful.
This is result of computer type test.
Only computer test. Computer the qualifying marks is 140.
Yes.
But according to my calculation, I obtained the answer sheet through under RTI Act from the authority.
Yes.
According to my calculation, I will get much more than 140.
Yes.
But they have not disclosed what is my marks, how they have calculated one, because there is a guideline. There is their guideline of their own, how the typewriting test
so
will be calculated.
It is a recruitment process for appointment of
clerkship examination.
So appointment of clerks in the state government.
Yes, my lord, state government.
And the examination process comprises of typing test and
written test, typing test, then computer test.
So writing and typing you have
yes,
cleared, and
that's why they have allowed it in the computer test.
So the scheme is that only if you qualify in the first 2 rounds, then you will have computer test. When after computer test, is there any other stage?
No, nothing is there. After computer test, the final panel will be.
All right.
Page 45 is the guideline. How the computer test will, the typing test will be assessed. Complete guideline is there. Following this guideline, the petitioner himself calculated, and they will get, according to them, they will get much more than 140.
So, what is the law? The student self-evaluates, and on that basis, the report.
But I'm not that. I'm not that saying that my assessment is conclusive. Let them produce how they have calculated and what is my score.
No, why the court should exercise jurisdiction? Everyone can say that I should have got 10 more marks. For everyone, we will direct them to produce the marks.
There is a specific guideline. But following this guideline, my lord, if there is no guideline, then otherwise, my lord.
We have understood what you are saying. You are saying that it cannot be arbitrary. In substance, you are saying that the award of marks cannot be arbitrary.
Yes.
But everyone can say that. Every candidate can say that award of marks is arbitrary.
No, then the guideline.
So where is the manifest arbitrariness for enabling the court to exercise jurisdiction under 226
See the guideline one.
on a writ petition filed by a candidate, not alleging any malified, not alleging any procedural irregularity, nothing, and saying that I should have got X marks instead of Y. Please ask them to disclose everything. Now, is the court supposed to do
Yes,
this?
kindly see once the page 45. Page 45.
We are at page 45.
Clause 6, calculation of marks for accuracy.
Yes.
Marks, number of type words 0.33, major mistake minus 0.15, or minor mistake. So following these guidelines, if I calculate because I obtained my score sheet under RTI Act, if I assess following this guideline, my marks will become much more than 140.
That is precisely what we are saying.
Yes.
Then every candidate can come and say that instead of X, I should have been awarded Y, because according to me, this is the marks I am entitled to. So based on a self-assessment of a candidate who has participated in a proceeding, should the writ court ask the authorities to produce this and that and make out a case for you?
Kindly direct them to assess by a third party, my lord.
Why? Why? Where is the mistrust?
Because it is apparent on the face of the record.
You may say so. You may say so.
Because
you can say
if
we have to find it. Your saying will not suffice.
So then let them produce the record.
We don't find any reason.
Because they have passed a one-line order.
Let us see.
Kindly see the page 8.
That is, what else should they say?
What is my score and how they have assessed?
So where is the
guideline? If my score is more than 150 and they have given 120, well, this is their arbitrariness.
Did you file an RTI finding your marks to obtain your marks?
Well, RTI Act to supply me the copy and the score.
Yes. Every disqualified candidate will feel the same way. Every disqualified candidate that I have not been awarded sufficient marks. So then in every case, the tribunal or the writ court will start asking them to show how they have examined, what marks they have given, what is the total.
Yes, I have the.
Let us see, where is your RTI application?
Has not been answered. Kindly allow me to file a supplementary evidence to that effect. So that RTI application.
Where have you stated that you filed an RTI application? No, in the OA. Show us from the OA.
Another petition was pending since 2024 on the self-employed corporation. PhD since 2024. Another petition was pending.
Yes.
By this petitioner.
59.
59 of 2024.
What is the prayer in that case?
There was.
In that case, what happened?
Have you stated about its pendency in your writ petition?
What happened?
Have you stated about?
Different ground.
Very well.
Different ground.
Very good. Very good.
No, not different ground.
Very good.
What I am saying, what is the ground?
All right, you proceed.
Page 24 of the way. 6 of the way. Paragraph
Q1.
Where is an extra L? Okay. Very good. So everything you are withholding from the court. Sorry. Yes. No supplementary now.
That field also they are supplied without any assessment. They are supplied under RTE Act. There is no assessment. Yes, I have also stated.
Yes. No ground has been made out. There's only two grounds in paragraph S and T, nothing else.
That's the point, my only ground, but regarding my assessment. In their, according to their own guideline, they are supposed to assess my answer script according to their own guideline.
Yes.
They have not assessed the same because the complete guideline should how the mark will be awarded and what is the major mistake and what is the minor mistake, that are also defined in the guideline. Can you please 45?
Very well.
Major mistake and minor mistake.
That we have shown already. Yes.
Yes, ma'am.
Yes.
After deducting your marks, my marks will be more than 140.
Already. That's all.
In the input order, they have not disclosed nothing but what is my marks and how they have assessed.
That's all.
Yes.
Heard the learned advocate.
I have served, my lord. This is my affidavit of service. My lord, here, my lord, the learned tribunal is not available, so my lord, I file this writ petition, my lord. Petitioner retired from service, my lord, 2017, my lord. But due to my lord, pendency of the matter, my lord, they have not taken any steps to my lord, my short point we involved in this matter, my lord. My lord, petitioner appointed a casual worker under the Kongsabati Canal, my lord, with in the year 1984. Regularization made, my lord, in the year 1996, my lord. But, my lord, they have give effect from 1997. So, my lord, petitioner prepared this way application regarding, my lord, regarding the pensionary benefit with effect from 1996, my lord. Because, my lord, as per the settled judgment, my lord, passed by this honorable court, my lord, I have already annexed the judgment also, my lord. My lord, the court has set aside that order, my lord, and my lord, give the effect, the appointment from the 1996, my lord. My lord, I have stated in my OA application as well as the this application, paragraph 4, page 9, paragraph 4, my lord. Page 9, paragraph 4, my lord. And my lord, my OA application, my lord, running page 25, my lord, internal page 6, my lord. Judgment, my lord, page 49, my lord. Relevant portion is, my lord, page 50, my lord. Page 51, my lord.
Why you have annexed the order only up till 21?
All annexed, all order I annexed, my lord.
No.
Yes, my lord, kindly see, my lord. My lord, all tribunals order, my lord. My lord, page, my lord, page 80 onwards, my lord. Page 80 onwards, my lord. My lord, all the date, my lord, they have adjourned because, my lord, the single bench is there. So, my lord, division bench is not available. So, matter was adjourned, my lord.
The last certified copy that you have supplied
Well,
is of of February 21. After that, there is no certified copy. Why?
So, certified copy was not available, but till date, my lord.
Then how you have filed it? And you are proceeding on the merit as if it is in order. Rather than pointing out that there is a deficiency, you are proceeding as if it is in order. On going through the writ petition, we find that
Item number 3.
Item number 3, my lord. Item number 3, my lord, I pay, my lord, 1 day's accommodation, my lord, because, my lord, yesterday you have opted, you have to pay for time, my lord. My lord, 1 day's accommodation, my lord.
very well, not today.
Not today, my lord.
Yesterday she has paid, so today you must get.
No, my lord, that is not a fact, my lord. I am miss some judgment, my lord. I miss some.
Yes.
Keep it up, like. Keep it up.
Item number 4.
Lord, I appeal for the
Behalf of the state. It has come for the first time.
first time, my lord. This is the affidavit.
Find out. The learned advocate for the state submits that they will do it. These matters are unnecessary.
Item number 5.
This is also my application, my lord. Your lordship, kindly have a look at the order dated, my lord, 9th of December. Your lordship's order.
Minister not today.
How you are keeping the file? Just see. This is the way the court record should be. What is the big problem in just making it like this? When you just see, it is all phone. This is the way record should be kept.
To kindly have a look at the order dated 9th of December, my lord. Your lordship has explicitly have stated everything in that order. Paragraph 3, my lord, your lordship quoted your lordship's earlier order, and paragraph 3 makes sense.
It has been accepted in all the cases. Yes, where is that? Show us. It is the same now. Oh.
School name number 1.
So they will take the steps.
Lord, let that be pending, my lord. Let them come on at least on the other matters, my lord. They have come with something, my lord. It's only
Why in this case you are making an exception? In all other cases they have come with. You are testing their patience. Yes. And you are testing our patience also. They are buying their peace by saying that that let them do it. You are taking all the time in the world. What is it? No, but it does not say that the authority has decided to accept. You have got it. Then bring a written instruction. You bring a written instruction. Yes, we are informed by the learned AGP.
It yet, Lordship. If Lordship kindly grants us 1 week time, we'll get the notification.
The commission was also a party there.
Yes,
my lord.
but the commission is not appearing.
With me, my lord. I have only 2 copies, my lord. It says by promotion in consultation with Public Service Commission West Bengal from the rank of Deputy Chief Probation cum Aftercare Officer under the Department of Correctional Administration, Government of West Bengal, on completion of at least 1 year of service as Deputy Chief. I fulfill all the things. My lord,
Now,
I do have only
the
2 copies. My lord.
technical difficulty will be this, Lordship. We cannot create a post. The post already someone is appointed there. what the direction is that the petitioner should be appointed as the officer. So now we have to create another post to give him the appointment. The only charges, the only fault which we have done is that there is a disciplinary there is a proceedings going against the petitioner. Now the only fault we have done that we have taken steps ahead with prior to the submission of the final charge sheet. So that's the ground the petitioner has taken for appointment, for his appointment. But
Not
now
appointment, promotion.
promotion, right? Pardon me, Lordship, for promotion. Now
But
here,
that is the only ground he's required to take. He's not required to take any other ground.
Yes,
The law is very well settled.
is that already someone is
You
there.
must have seen KV Janki Raman's judgment.
Yes, yes,
So
yes,
therefore,
Lordship.
yes,
But now someone is already there, appointed as an officer.
whatever it
But-
is,
But we cannot create a new post and appoint the petitioner. It has to be created by the commission, and the direction also has to come from the commission. We cannot do this
commission
with
is a
the
consultative body. It is not a appointing authority.
No, Lordship,
As we are told, we
Lordship.
don't know.
Please, Your Lordship, kindly have a look at it.
You are referring to something different from this.
Yes, yes, yes. I'm referring to something. There is another notification, and the constitution also says that, Lordship. I think Article 320.
Yes, what does the constitution say?
Lordship, I'll just a second, Lordship.
It is in consultation with the Public Service Commission from the rank of Deputy Chief Probation
are
Commander.
Recommending authorities, Lordship. We can only recommend names. But
You are a state government.
He's a state.
I am the state government.
He-
I am the department. I am the department. We have recommended names to the Public Service Commission. The commission,
From where are you saying this procedure?
that's.
We have not seen any such procedure till now.
Lordship, kindly gives me one.
Don't
time.
recommend.
No.
You take a consultation. It is an exercise of consultation with the commission. It is not recommendation.
Direction comes, we cannot create the position. Lordship, kindly considers this point.
Where is we asked you to come with the procedure. Why?
Lordship, 1 week's time, Lordship, I'm seeking. I'll get back with the notification, Lordship. 1 week's time, Lordship.
Give her a copy of this so she can take instruction on this also. In pursuant to the court's earlier order, the learned give her a copy of that notice.
WhatsApp third, my lord.
Grateful.
Item number 7.
I am appearing for the petition. Sir, may I file the affidavit in reply? It's a matter of compassionate appointment, my lord. It has to be.
Service, what is this? Reply.
Yes. There was a direction, my lord. Affidavits are exchanged. Well, the petitioner was the father of the petitioner was initially appointed as a roller driver, my lord, as a work charged employee. Thereafter, my lord, pursuant to a notification of 1974, they were to be absorbed as a regular employee. And my lord, for 37 years he worked, my lord, pension they were getting. Now, my lord, when he died in 2011, application was made within time.
Can you give us the date of demise?
Lordship. 11/2/2011, my lord, the employee died.
Yes.
And 21/2/2012, the application was verified by the executive engineer. Application for compassionate appointment.
21/2,
21/2/2000.
after 1 year.
It was verified. Application was made, but there is no issue of delay.
All right.
Now, my lord, initially, my lord, my application was rejected on the ground that since he is a work charged employee, so therefore he is not eligible for the scheme. My lord, original application was moved before the tribunal. The tribunal held that in view of Manoj Mishra's case, my lord, it is all there. My lord, may I take your lordship to the
Tribunal's order.
yes, the initial order, the first round of
Yes,
the
yes. Earlier
yes,
order.
Yes. My lord, will kindly come up to kindly comes to page 36.
OA 40.
OA. Yes. OA 40 of 2019. My lord, may I take your lordship to page 35?
Let us read.
Well,
Just. So where is the order passed by them after this?
Well,
Page 39.
page 39.
39.
Like. No, my lord, here, my lord, may I join the issue? My lord, after this direction, my lord, the authorities, my lord, considered the case entirely on a wrong premises, taking into consideration the scheme of 2013. Whereas, my lord, my application is of the year 2011.
Yes, so what is your submission about this reasoned order?
Reasoned order, my lord, first of all, my lord, my case has been considered under the scheme of 2013. But my lord, the law is, my lord, subject to correction that since I have applied in 2011, my father expired in 2011, my lord, my case has to be considered as per the existing rule as it was there.
And what difference it will make if it is considered as?
My lord, in the earlier rules, my lord, there was no specific definition of a government employee which can be, my lord, interpreted in this fashion. My lord, if I take your lordship to the earlier rules,
What is the ground for rejection which you have challenged?
my lord, ground for rejection I have challenged, my lord, that there is this 2013 is not applicable to me, and
Sir, what is the ground in the rejection order which you do not like? What reason in the reasoned order is not to your liking?
my lord, I have been, my lord, held to be, my lord, not coming within the eligibility criteria.
That's all. There's no question now whether your father was in regular employment or not. That issue is over.
That issue is over, but in their opposition, my lord, in this writ petition, they have again taken that point.
They may do so, but that is the
That issue,
reason.
my lord, according to me, my lord, that issue has been decided finally. It has not been agitated further because after the order of the learned tribunal, my lord, the matter has been put to an end.
No. After the reasoned order, it has been put to rest. They have accepted it. You come to page 42, clause 4. How can they say in the written objection?
Well,
Please read what clause 4 says.
in spite of considering the deceased employee deemed to have been absorbed in the regular establishment,
Yes.
the present applicant is ineligible on other criteria.
They have, so now it is ineligible on other criteria.
I bow down to your lordship.
So therefore, what is wrong? That's what we are asking.
Yes, my lord, they have, now, my lord, kindly sees, my lord, my lord, the clause 3, just the earlier.
No, therefore, if you say 2011, 2013, therefore we asked you if you, even if we consider your claim under the 2011 circular, are you going to get over these two grounds that you are not, you have only passed class 6 and that you are above
I
45?
can get over these two grounds, my lord, even under the, my lord, the existing, the present rules.
So let's come to that.
Lordship.
Yes.
My lord, kindly comes to the, my lord, affidavit.
251.
Affidavit in opposition, it is the rule is there annexed.
Let us see EMP 251.
251, right.
Yes. It is of 2013.
2013.
So you are 74 born. Your father died in 11.
Not.
So how old were you at the time of his demise? 74.
Well, 74, 2011, well, then it will come down to.
You should have a ready-made answer to this.
That was 37. 37.
So on the date of demise, you were less than 40 years. And how about the educational qualification?
Educational qualification, my lord, I am coming to the relaxation clause. My lord, kindly comes. My lord,
Did you make an application for relaxation?
Well, the scheme doesn't speaks about, my lord, making a separate application for relaxation. Well, it is for the authority to consider it, because, my lord, I am supposed to make an application, my lord, in distress for my for consideration of my case. It is not a matter of right. Now, if the authority, my lord, feels, my lord, they have this power, my lord. These rules does not say, my lord, that I need to make a separate application for relaxation.
Very good.
This is my humble submission. It kindly comes to page 12 of the opposition.
No, let us see 251. Where does it?
251, my lord, I'm placing, my lord, for convenience, my lord, that is.
There is a note below some provision. Note.
My lord, I am placing, my lord, eligibility 6, clause 6, eligibility. Then, my lord, the next page.
Note B.
Yes. Note B. Note B and note A. These are the two grounds, my lord, on which.
Note B is relevant for you.
A, my lord, yes.
A may not stand in
Yes.
your, you were not overage
Yes,
at the
but
time of
according
his
to them, my lord, when at the time of the consideration at present, I am overage.
That is.
And
that
relaxation
is-
in educational qualification may be granted in eligible cases for appointment in consultation with the finance. My lord, my lord, I have gone through the entire scheme, my lord, nowhere it is, my lord,
So is there any guideline when they are considered eligible for educational relaxation in education?
Question has to be considered whether the age limit is there or prescribed qualification. So prescribed qualification minimum 8 standard, group D star, and mother within the page of 37 years. 37 years other department and 27 years in a police department.
He is not claiming in police.
Other department maximum 37.
No, 40 years.
40 years for the country, but in age, according to the calculation,
According to his calculation on the date of demise, he is 37. No. So actually he is not 37. You are correct. He is less than 37. So therefore we are asking you, this note B to 6.
Yes.
After all, when do you utilize or invoke this? Under what circumstance? It says in eligible cases. So where is the eligibility for this? Is there any prescription?
Eligibility means but education qualification, one of the
Sir, please see note D.
yes.
What does it say?
Relaxation in education qualification
May be granted.
may be granted in eligible case.
So when he is eligible for educational qualification relaxation, where is the guideline? When he can be considered eligible for relaxation? It is a total discretion in the hand of the government, or there is any guideline?
According to my humble reading, if somebody files an application within the time, then case will be considered. Then
That objection you cannot take.
no, I'm not saying
You
that.
have taken an exercise pursuant to the tribunal's order. You have not challenged the tribunal's order. So therefore, all those issues are now taking a back seat.
Yeah.
Only two grounds are there in the reasoned order. One is the age, other is qualification. Age, we don't know what we will do because he was eligible on the date of demise. So far educational qualification is concerned.
Qualification.
Therefore, we are asking you, ineligible cases means what? Is it that if you like someone's face, you will do it, otherwise you will not?
If he fulfill other conditions, somebody.
So can we take this statement of yours on record?
I shall have to ascertain from the department.
Therefore, we are asking you. Yes, let him find out. Yes, heard the learned. किसका है देखो ये इसी का है affidavit in replies to
Item number 8.
But in this matter, I mean, for the petitioner being assisted by Mr. Firdaus Sami.
yes
Nevertheless, our complaint was that there were wrong question papers, wrong assessment. Now PSC has filed an affidavit, practically admitted our allegation. My lord will kindly take up the affidavit by PSC. That will, I think, resolve the issue.
November 2024.
18
November 2024 evidence. Held by one Sanjoy Dash.
respond number 3 and 4
Yes.
Yes, my lord.
They are the Public Service Commission. My lord will kindly turn to page 6, paragraph 8. The last but one paragraph, has my lord got it?
yes we have it
It is a fact that the petitioner had to be awarded 2 more marks in GS and CA paper. Therefore, her marks would now be 55 in the SAIT paper and 276 in aggregate.
yes
Now, if they admit that my aggregate is 276, then I am above the cutoff mark.
yes
The latest cutoff mark is 275. My learned junior will hand over PSC's own.
but there is a
Notification.
tie they say there is a tie
No, that was when 276 was the cutoff mark. Now,
Earlier.
cutoff mark has gone down to 275.
it has gone down
No, Lordship, I have no such instruction. The case was, there was a tie, and just because the other candidate has got more marks in
where
the
have you got
personality
this?
test.
Website.
Website
Yes, PSC's website 18 December 2025.
But that if she
latest
doesn't have the instruction, let her take instruction. I think
find
that
out
will resolve the issue.
find out
That
what is
will
the
resolve the issue.
Last
if it
page.
is so simple an issue then we don't know
Yes,
find out.
then
Last page.
You
Latest.
please take instruction on this. You come back with instruction. The learned senior advocate appearing virtually. Ninth.
Lordship.
Your second, third, we have fixed too many matters.
deeply obliged.
Item number 9.
I am here for the retention amendment. I am declaring
কি অবস্থা হচ্ছে ফাইলগুলো আবার কি
Yes, my lord, this matter was extensively heard, my lord. Even written notes were also filed, my lord, when your lordship was sitting with my lord Justice Bhattacharya.
See, we are most likely to assemble on 30th. On 30th of this month. So let it come on that day.
30th of this month.
Yes.
My lord, what has happened, the next matter, item 10, my lord, the code issue is identical, my lord, in both the two matters. So, my lord, that is why on the last occasion, your lordship directed the matter to be appear on a event date, my lord. So, and your lordship expressed your lordship's desire to heard it afresh, my lord, subject to what my lord, your lordship says.
Let us see what the order has been passed earlier. If there is a order showing a consideration by the other bench, it can go on 30th because we are likely to assemble on 30th in the second half. If there is no consideration, was it considered by us in the other bench?
Because hearing item 9 Millard Biplab, extensive hearing Millard concluded for sale.
Therefore, we are saying on 30th that bench is to assemble.
Oh, I see.
So we
Then
can.
Millard, the next matter.
So now the next one will.
That is also.
Next need not be. Whatever order is passed, it can follow.
But Millard,
if the issue is one and the same,
the fundamental core issue is same.
Therefore, if in that DB we decide something, that will ipso facto apply here in the next case.
But is it possible for my lords to pass an order since that bench, Millard? Because Millard, sometimes Millard, the interaction of a litigant through counsel, Millard, with the bench, Millard, it is not, Millard, a teasing illusion, but sometimes, Millard, the aspiration, Millard, standing on the floor of reality. If my client wants.
Yes. So what observation you want to do?
That this matter may be tagged with this.
We do see that bench will assemble for 3-4 cases. That bench will now, including this, will assemble for 3-4 cases. I am not very much eager of making a long list on that day. Let it be decided. We may direct list after disposal of that case.
Let us start the process, and in the event your lordship is, because there are some, Millard, certain shades of difference, Millard, with regard to the next item, Millard, and but the core question is same. I cannot.
So therefore, we are saying let it come after that. Very good. Very good. What is the issue?
Issue is, Millard, the horizontal reservation.
Oh yes, yes. Now I remember.
And Millard, question is, Millard, without having any cut-off date, whether this can be done after the.
So let it come after 9.
After 9.
After disposal of 9.
Yes.
Let the core issue be decided. Yes, yes. Whatever nuances are, we can consider.
Yes, yes, yes.
Subject.
And Millard, the matter will be taken up on
30th. We are assembling.
কবে যা হচ্ছেন বসছেন
30th we are assembling. Yes, 30 is on Friday. On that day, this can be listed. We are informed by the learned advocate. See, it will have to go before the Honorable Chief Justice. We will try that it is in.
As your lordship.
10 will come after disposal of 9.
As your lordship. He is led by learned advocate in item number 3.
You are here.
That's right, not my duty to inform you. Nothing. But inform.
Item number 11.
Earlier occasion, my lord, on 8 December 2025, the lordship was considering the financial expediency of the petitioner and directed the department to prepare paperwork and directed the petitioner to file requisition. Requisitions have been filed, translation copy has also been filed, but they declined to prepare paperwork. However, my lord, I may, for my own, my lord, take measures to prepare paperwork within 2 days, my lord.
When you file the requisites?
I filed my lord immediately that time, my lord. But however, my lord,
When? Give us the date.
7th January,
Where is the receiving?
no receipt, my lord. No receipt is there.
Sir, please have a look. You're making such submission, therefore we must bring it to your notice.
But on the other hand, my
Please
lord,
read, sir. Please read. You are telling us that the office has declined. And this is on instruction.
my lord,
My lord, I personally visited the office of the paper book, my lord. I showed them the order. They said that we have to file the paper books, my lord. But when I told them that the court has directed us to prepare just to deposit the requisites of the paper book, they declared that they will only receive the paper book, my lord. They kept.
Just now you instructed him that you have filed the requisite on 7th.
Lordship, I have personally went there.
Just now you instructed him that you have filed the requisite on 7th.
Yes, Lordship,
What yes?
Lordship, I, along with the requisite, visited their office.
You said you have filed it on 7th. You gave a specific date.
Yes,
Can
Lordship.
we ask where is the receiving?
Lordship, we.
What kind of submission you are making? You are in a court.
however, my lord,
This is the way.
however, for my own, my lord,
Making allegations against everyone without any substance. First you say you filed, now you say they are not received.
Lordship, they denied to receive the.
You should have said that in the beginning. Why did you say you filed it on 7th? You are trying to tell us that our order was not complied by the department, that they declined. I have given the requisite, still they have not done it. And you have not given the requisite. You could have come to this court that they are not accepting the requisite. This is the way.
however, my lord,
You are telling us in open court that the office is defiant to the court's order without any basis. Casting aspersion on the court, department and registry. We will not allow any officer of the court to be browbeat by such submission, factually unsustainable. Since he is going to file, you file it. We are informed by the learned advocate. After 1 week. Please serve copies. They will give copies. 27th or 2nd, when we should have heard. We have fixed too many matters on 27th. It cannot be. Then it will come on 10th, 9th or 10th.
10th. 10 করে দে যে ডিপার্টমেন্টে নামাবি আবার এরা Item number 12.
My lord, I am praying for not this week. My senior is ill, my lord.
Special case. Oh,
Give a date. Tell him, please tell him.
third, fifth. Item number 13.
Item number 13 also, and for the petition.
Ah.
What happened?
In this case, your lordship, the petitioners is the candidate who participated in the recruitment process conducted by the your lordship PSC, where your lordship, the petitioners admittedly doesn't have the your lordship the OBC certificate at the time of the your lordship the closure of the date of the
Opposition is
notification.
already filed. Opposition is filed.
Since your some law point was your lordship framed by your lordship.
In the tribunal, any opposition was filed.
No, your lordship.
Then let them file opposition.
Since your lordship, one point was
Find out. In the tribunal, any opposition was filed by them.
well, no.
Then let them file. Yes, let the opposition be filed.
On
23rd.
It is already complete.
February.
In that case, they will.
What is to be done? There is no scope for passing.
23rd February.
So in that case, your lordship will have to direct them to create a
Even
post.
today, if we pass an order, it will be the same. Situation will not change, therefore.
Appearance. Item number 14.
You don't want to file a reply, we should proceed. What is the case? We don't remember.
The case for compassionate appointment. My mother died at the date on that 2030. My mother died. Thereafter, my father applied for compassionate appointment. The year, sometime in the year 2022, my father got incapacitated and
You applied when?
after kind of a marriage, it is 5 months.
All right, so that was still pending
Fine.
till 22. In 22, he became incapacitated. Then?
And I have applied, I have applied, and they said that that time I was minor. So I can.
Just a minute. In 22, where is the communication that he is incapacitated?
It was in Bengali, my lord rejected me to translate the copy. But I paid 4 of the supplementary.
They have rejected. Where is the rejection? Is there any consideration by the three-member committee? In one case, Yes.
Oh, that order.
Has this judgment been implemented? Huh?
My instruction is no.
What no?
It has not been appealed.
No, we are asking whether it has been implemented. Because if this has been implemented, then we can rely on this. If this has not been implemented, then we will not be in a position. Before we rely on this judgment, we must be sure that it has been implemented. This is
It's not
more
there.
than a year old.
And if it is not, then that amounts to contempt.
It is of February 25. Yes. No, it can be ascertained immediately. If no SLP has been filed, then not today will suffice. It will come in the next week. Not today. You also find out. You look up the website of the apex court. You can find out whether this judgment has been appealed or not, whether SLP has been filed or not. There is a drop down menu in case status. When you go for a search, there is an option of searching it from the court records. That will direct you to the state. You select your state, case number.
Item number 15.
Input. Go to the case status. The drop down. Which case? Case number or state case. And if you say reference to the state case, then you will have to select the state. Then it will take you to Calcutta. Which kind of case you are? Then you will say WPST. Give the number.
Madam, I am led by Mr. HON'BLE praying for not this week.
And the state council?
Lordship, the order has been passed and Lordship kindly goes to the order last part. MCA benefits was initially granted.
Which benefit?
MCA. MCAS. Benefit. Granted. During that time, this dispute going on. Subsequently, the charges were filed, and therefore the MCA benefits were withdrawn
Because?
There is criminal. If Lordship kindly comes to the.
What is MCAS?
MCAS is Lordship specified that it's just.
Anyway, come back to not today.
My lord, kindly not this week, my lord.
Not today.
Item number 16.
The opposition has not been served on us. If they serve us, let us my lord, go through and come back within 1 week, my lord. Because my lord, the conducting advocate is not present today as well, my lord, due to some personal difficulty. Which time may be given for opposition, my lord, for reply, my lord.
Affidavit in opposition.
Item number 17.
Item number 17, my senior Ranjan Bhattacharya appearing for the petition. I'm praying for only not to the He is not coming to court for regarding for health issue. Lord.
Not today.
18.
Yes, Lordship. 18, Lordship, I am appearing on behalf of the petitioner, Lordship. Matter relates to compassionate appointment. Lordship, petitioner's father died on Lordship 12/3/2016. Within 2 months, he applied along with his mother. Lordship, the authority, Lordship, rejecting the application only for delay of 2 years, 8 months instead of 2 years. That is the only point they have taken. Now, Lordship, I have annexed the impugned order.
When did you file your application?
Application, Lordship, filed on 12/5/2016 and died on 12/3/2016.
12/5/16.
12/5/2016. And petitioner's father died on 12/3/2016.
Within 2 months,
2
you have
months, Lordship, I have filed. They have accepted it, and pro forma application also filed, but that was insufficient due to Lordship. Lordship, the retirement benefit was not settled. That's why, because Lordship, the father, he residing of state of Bihar, so it is takes some time. That's why, Lordship, from Bhagalpur Treasury, it is takes some time. That's why thereafter, in their 2018, they have filed every document that has acknowledged by the authority. And Lordship, ultimately the rejection order is, Lordship, kindly see page number 60.
Date of demise is 12/3/2016.
2016.
And the plain paper application is 12/5/16.
12/5/2016.
And when did you submit the pro forma?
That's a pro forma also within time, but it was insufficient. It is
We are asking you when, why do you say
also
within?
on the same date.
On 12/5/16.
12/5/16.
Where have you said that in your OA? Show from your OA.
Lordship, yes, Lordship. Kindly see page number 39. They have accepted, they have Lordship, acknowledged it. The Deputy Superintendent NRS Medical College. Lordship, page 39. Your father, Shankar Das, LDC NRS Medical College and Hospital, died in Handes on 12/3/2016, and you applied for a job compensation appointment in pro forma application. This is insufficient to process the matter. Thereafter, Lordship, kindly see 10, number 10. Date benefit and all relevant documents, including last pay certificate of the deceased employee, on 28/11/2008. That was not submitted because I have not received that benefit. It takes some time. And Lordship, they are at page 49.
LPC you have to submit.
Lordship,
Last pay certificate you have to.
last pay certificate as well as Lordship, the disease, Lordship, the death date benefit, retirement benefit. That is takes some time.
No, it is not retirement benefit. This is death benefit.
Death benefit. Death benefit. Yes, Lordship.
Perhaps they give some amount for cremation and all. It
Yes,
is referring to that.
Yes, Lordship. That was not in my hand, Lordship. And 49, Lordship, 7/12/2018, I have submitted all the documents. That is acknowledged by them. Page number 49.
So how your order is sustainable? In November 16, they are saying that you submitted the pro forma application. Yes. In a pro forma application, this they are saying within 7 months of the death. So there is no question of not filing a pro forma application. No, not without any particular. Without insufficient means something was lacking. So therefore, pro forma application has been submitted. Now come to your rejection order. It is totally out of line with this letter.
8 months.
No, here you said you have applied after lapse of 2 years, 3 months. Here you say you have applied within 7 months. How these two can be reconciled? This letter is of November 16, page. So within 7 months. And here you are saying you applied on pro forma after 2 years, 8 months. You don't say that. You don't say that. You say you applied after 2 years, 3 months. You don't say that still some information is wanting.
And yesterday, your Lordship, one matter decided.
Where is your opposition? Let us see. When he has already submitted the document in 18, why you have asked him again in 21 to come with the documents? On 3/10/2018, as per your opposition, you see paragraph E at page 3. On 7/12/18, he has submitted the documents. This is your statement in the affidavit. But again, you say that on 11/8/21, we asked him to submit the documents. And then we have said, what is this? You see what you have said in paragraph E. Submitted the documents on. Yes, that is what you are saying, submitted. You are not saying this time it was insufficient. When he has submitted, then why you have again asked him to submit documents? Again, you see in paragraph G, on 11/8/21, requested the petitioner to submit documents. Again, he has submitted. And then in 23, rejected that it is belated application. Where is that? You say he has already submitted in 2018. Then why you asked him? From where we will find that it is incomplete? Neither you say in paragraph E, nor you F, G, nowhere you say that document was incomplete. The impugned order does not also say that it is incomplete. It is only saying that it is late. Page 8.
Is there internal communication? 28/2/25 স্যার ডেটটা দেখুন।
Page 5.
Any copy of the paper application? Page 5 of the petition.
Page 5.
R2. Page 5 of the opposition. Yes. Yes.
1116. Memo number 9448.
Yes, Lordship. Page 39, Lordship. 39.
Yes, there is no question of tampering. This is our document issued by the office. No, see, what you have drawn attention is you are saying he has filed it in 18. He has struck off the year and instead of 18, he has made it 16. If that is the situation, then how in November 16, the department is issuing a letter that pro forma has been submitted? You see page 39. Well, cannot be. Your stand is incoherent. Nothing. Yes. Or the learned advocate for
Item number 19. Acha, 21. Item number 21.
The appellant, Your Lordship. Lordship, on 25th July 2025, there was Your Lordship's order for the state to obtain instruction. Since then, they are taking only time. So till that, did not have any report, Your Lordship. I may start with the case.
And where is the order passed in the case of Pritam Ghoshal?
239 is the order passed by the division.
239.
239.
কালকে 40 খানা থেকে যাবে পরে সস্তা আছে। রাইডার করে রেখে দাও।
Yes. Page.
Same issue. The division bank. Same division bank. Take a content view. So for a startup market.
Page 40.
40. Where is original picture?
Have you seen the order he is relying upon? Have you seen the order that he is relying upon?
Yeah.
Page
Same
230.
division bank. Same division bank. Same issue. Cut-off marks was paragraph 33.
No, it's not a question of cut-off marks. He's saying whatever marks he has got, based on that basis, you process his claim, because cut-off is noted in the order of the division bench. The cut-off marks has been taken note of in the division bench. So if he is above that, he will be in. If he is not above that, Cut-off marks, yes. Where is that? The same exam. There may be, but this is governing the exam in which he has participated. There are so many judgments to the contrary. How he can be deprived parity with this petitioner of WPST 9 of 21? How can you deprive? If you have given that benefit to him, he has approached the court earlier. It is a different thing that that case was decided before him, but he has approached the court earlier. His writ petition is prior to Pritam Ghoshal. So you cannot deny him parity. You have suffered a judgment regarding this recruitment process itself and you have implemented it. He is claiming parity. So there may be a point of law decided by another court in another case, but this is governing the very same recruitment process. And you have accepted the position. Then how can you? You cannot.
Until candidate is recommended by the PSU, we have no power to appoint him.
2019, and when the order was passed. But this order was, judgment is passed in 23. So therefore he has to be recommended. You have not said there is no vacancy. It's not your stand. No, in the tribunal there is no such a stand recorded.
No, tribunal does not dispute.
Huh?
Tribunal can see the order of the tribunal.
It is still pending. Anyway, but here also you have not denied. Here also you have not denied. You have chosen not to file any objection. 3-4 adjournments have been granted. You can't keep waiting for ever to file an objection. You are relying on the other judgment. How can you? You cannot. This is covering the same recruitment process. The same benefit will have to go to him. You introduce the cutoff mark after the interview. No, madam. No, madam. Then, if you have implemented it, how you can say? We cannot review that judgment which you have accepted and implemented. There is no basis for you to contend to the contrary. You cannot, you don't have the option, you don't have the opportunity. These are finding of facts which have assumed finality between the parties. You are bound by those findings. You cannot contend to the contrary. Paragraph 18 of the order has concluded this aspect at page 243. Paragraph
175.
Huh?
175.
No, first see paragraph 18, 243. 243. Paragraph 18.
He has been taking instruction since July 24. So many last indulgence on still
This was cancelled as executive with the same, should not be different. That would have been implemented. That would have been implemented by
Which page? 40. Page 40. Come to paragraph 18. Why paragraph 3? 18 is the finding. 18 is finding and 18 is implemented by you, not questioned ever. You cannot question now. What the court found is you introduced by way of a notification, you introduced at discretion to specify the qualifying marks. Cut-off marks, qualifying marks in the interview. That you published before the interview. But qualifying marks you published after the interview. You expressed that I will retain the discretion to do this, but you exercised that discretion after the interview. That is what the court held. They did not know that what is the qualifying marks. In paragraph 18, that is the finding.
2016 and 2020. But the vacancy will be filled up.
How can we? There is no scope for any such doubt. 2016 recruitment process, 23 order passed. That must have been implemented by 24. At least if you have acted with some diligence, sometime in 24. We are away, and today there is nothing to suggest that there is no vacancy.
No, I'm not sure.
You are sure? You are sure because we gave you 4 opportunities, you have not filed anything. So you are sure that there is nothing wrong. And that for want of vacancy, he cannot be made to suffer. If there is a finding, then he has to be given the benefits.
Supervisor post has to be created.
Do it. It is for such unique and extraordinary circumstances that the concept of supernumerary post is there. The law is settled. It cannot be given in every case, but for such a case where there is no dispute now in view of the judgment passed in WPST 9, he is not a fence sitter, rather he was in the court before WPST 9 of 21. Then how it can be? He cannot be deprived.
I would expect that somebody will be successful in the petition, and if no interim order, if there is an
After 23, you know, after this judgment, you know that you have committed an error.
No, whatever. No, that is by the PS.
Both things you know. The state and PSC both know that the court has found that there is an error. Both the state and PSC know that his writ is pending. Both things you are knowing. Where is the scope to say anything?
No, whatever. If there is an interim order, certainly
Therefore,
there is no interim order.
there is no, but your objection is not sustainable. There is no factual basis. There is no stand on record that there is no vacancy. And if there is no vacancy, even if we presume you are at fault, you know his writ is pending, you know that the same relief has been allowed in 23. Why? Why no vacancy is kept vacant for? Who stopped you? In your opposition, you have said anything about vacancy. So therefore, there is nothing on record. There is nothing on record. No, they don't want to submit anything. We have given them 4 or 5 opportunities. Last indulgence was granted in November. Now we are in January. What can be done? How can we deprive him of parity with the other person? It cannot be deprived. We have heard the learned advocate for the parties.
Original side matter item number 1.
Greatest humility, my lord. I would be seeking an adjournment. Notice was given to the other side, my lord. The learned arguing counsel, my lord, is in personal inconvenience.
In first matter.
First matter, my lord. And my lord, your lordship directed, my lord, the supplementary paper book. My lord, may I be permitted to file it? Kindly fix it, my lord, next week, my lord, or
Both sides are present.
yes, my lord.
For the officer.
Notice has been served upon all, my lord.
Why the supplementary affidavit?
The supplementary affidavit for
Documents were missing
documents were missing.
from the proceedings in the papers what they have filed.
Let's see. Let's see. Let us see the brief. You are appearing for the.
I'm not there, my lord. I have been requested to.
Oh, you are not appearing.
I'm not appearing. I'm just, my lord. I have been requested by my learned friend, my lord.
Then it will come after 2-3 weeks. Yes, take down. Mr. So-and-so.
Weeks to 2 weeks to.
I'm sorry to bother, my lord.
No. You have helped your friend. We appreciate. It's not that we don't appreciate.
Two PM fixed matter item number 19.
And I'm for the petitioner.
WPST.
WPST. The matter relates to, my lord, the petitioner, my lord, at the temporary, my lord, Polytechnic College professor. Now, my lord, we worked in a sanctioned post since 2008 after participating in the due process, my lord. Now, my lord, what has happened, my lord? After the, my lord, changed circumstances by the order of passed in Jaggo, Supreme Court, we are seeking, my lord, benefit to that effect that we should be considered for regularization. Kindly come to the order passed by the Honorable Tribunal.
Is there any order passed by the authority in this regard?
Tribunal was passed.
No, did you approach the authorities for
Yes,
this?
yes, approach the authority. No, nothing is given. Thereafter, we approach before the tribunal and tribunal, my lord, passed an order. Kindly come to paper book, volume 2, page 211 once. I just recollect the submission, my lord, made by 211 in the matter WPST 121 of 2025.
This is an order passed in your OA.
Yes. May I read the order?
No, we'll read. Don't.
Yes, 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 yes.
Yes.
And kindly, well, the tribunal, my lord, in the one hand, my lord, they are saying, my lord, to absorb the petitioner, applicants, or call the fresh recruitment. Now, my lord, on the part of the fresh recruitment, we challenge the order by filing the writ petition. The contention, my lord, kindly come to the supplementary affidavit filed by the petitioner before your lordships, my lord, on the last occasion, wherein, my lord, I attached an Excel chart showing the engagement of the petitioners since 2009, respective petitioners. One supplementary affidavit affirmed by Srimati Sharma Chattopadhyay. Service করেছে কি? চিঠি আছে কি? আমরা দিচ্ছি।
This is joining of all the petitioners.
Yes, yes, yes. Kindly see, there are in the item number 19, there are 4 petitioners, and kindly come to page 5 once.
So,
page 5, page 6, 4 petitioners.
Those who have been appointed in 2020 and 21, they are to be considered as par with those who have been appointed in 2008 and 9.
Like we appointed in the year 2009 after participating in the due process.
Again, we are asking you. So those who have been appointed in 2020 and 2021, they are to be treated at par with those who was appointed in 2008 and 2009.
Not that, my lord.
They are clubbed.
My lord, kindly see, my lord, 2008.
Sir, kindly see page 5 of the supplementary top at serial number 23 and 24.
Serial
You
number.
want them to be treated at par with serial 1 and 2.
No,
Is
no.
it possible?
It is the, kindly see the chart. This
Yes.
is a chart relates to petitioner number 1. Second line, top.
Yes.
This is the date of extension order.
Oh, this is their history.
Extension order, extension sheet.
So how many petitioners are there?
4 petitioners.
Only 4.
4. 2008 initial joining, thereafter the extension. On the last occasion, your lordship was pleased to give
Oh
the
yes,
direction.
we wanted to know.
Yes.
We asked you there for your file.
Yes.
Now we remember.
That is the order passed by the Department of Training, Technical Education and Training Department.
And where is the process of your initial engagement?
Yes. Kindly see the advertisement part also.
In 2008?
Yes. Kindly see the advertisement once, which is at volume 1, paper book. Page 37.
37.
Page 37. Work-in interview will be held in the Government Polytechnic Siliguri at all the petitioner participated in the process. Thereafter selected. And kindly see the nature of engagement.
And how does this process reconcile with the rule?
Kindly come to page 38 once. The answer, page 38. That is the Regulation 7 West Bengal Public Service Commission exemption from
What is the
consultation.
date of this advertisement?
Advertisement date is at advertisement on 8th November 2007. And kindly come to page 38 once.
No, this is later. This is of 2008.
2008, this is a notification publishing the result wherein the name of the petitioners are featured. And kindly see the
That's not what we are asking you. We are asking you, this is some contractual appointment engagement done in 2007. Now, at the time of your induction in 2007, there must have been some rules for recruitment in vogue. Now, without going into that rule of recruitment, this process has been adopted. So, what we want to know is whether the qualification prescribed in the rule, it was specified in this advertisement or not.
Advertisement, kindly see.
No, from the advertisement, it cannot be deciphered. It has to
From
be
the
read
rule.
with reference to the rule. Whether you have the requisite qualification, whether there was an
According to us, we have the requisite qualification.
No, you have to show us. Merely by saying that we are qualified, we will not take it. You will have to show that you are qualified, that there was sanction post, that there was a equal opportunity in
Sanction
terms of
post I can show before.
that there was an equal opportunity in terms of Article 14 and 16.
Yes.
These 3 things you have to show, and that you have continued for a particular period without an aid of any order of the court. Substantially, this situation has not been altered either in Jago or in Dharamveer Singh. None of these judgments have interfered with the judgment of Secretary State of Karnataka versus Uma Devi.
But the respondent also cannot use it as a shield.
Correct.
The
So
contention of the
therefore we say, first you have to satisfy that all these 4 parameters you fulfill.
But we engaged in the sanction post, that can I show?
That you are repeating repeatedly, that we have understood. You need not say it repeatedly. Again, we are saying you have to satisfy that you fulfill all the 4 parameters. Primarily, that is to be satisfied, then we may proceed further with the matter. So therefore, you sanction post, you say you can show from the records.
Yes.
There is an advertisement, you can show from the records. The continuance, you have filed a supplementary affidavit. So at least one thing which remains is, were you appointed having the requisite qualification in terms of the rule or not? So where is the rule?
That is a regulation 7 of the West Bengal Public Service Commission. It is mentioned in the notification, which is page 38 once. Kindly see page 38. The following government 31 number of candidates in the post of lecturer.
See,
with considered
as this notification appears to be that regulation 7 provides for making a stopgap arrangement.
Yes.
So under regulation 7, this has been done. We are repeatedly asking you.
Regarding qualification.
Yes. That is one parameter which until now you have not shown. Therefore, we are asking you. What was the rule or regulation under which the appointment was being made in 2007?
Yes, ma'am. Just.
And where is your representation? You said you have moved them earlier.
Yes.
Where is that? Maybe in that you have said, let us.
Representation is at page. Presentation before the authority, letter of representation, page 138 onwards. 130, 136 or 137. Just. Starts from 135. Sorry. Yes. না কোন রুলে লেখা আছে
So this is of 21.
Yes.
There is no receiving whether you have submitted it or not. We don't know.
In the against the ballot, our representation reply has been given by the.
Where is that?
139. And kindly see less than 10 years qualification in the just enhancement of remuneration.
No, this is not in response. This is not a reply. We don't know whether you have ever moved them. You have gone to the tribunal directly. Otherwise, there would have been a receiving. You have filed it in 21 and immediately you have gone to the tribunal. You have not allowed them to consider
But I have the copy of the my lord acknowledgement, which is at page 134 once.
WPST was filed when? Sorry, OA was filed
Way was filed.
immediately after the representation.
134 is the acknowledgement. Kindly see the acknowledgement of the representation I have attached. 134.
Oh, it was sent by post.
Yes, yes, yes. By post. And delivered confirmed. And way we have filed the way.
Yes, 1st March it was delivered and you must have filed immediately within 10-15 days.
Yes, yes, yes. It was affirmed on 9 July 2021. 9 July 2021. Till date, my lord, we are working. That is the scenario in this case. My lord. We are still working on the strength of the order passed by the authority. We are seeking regulation on the strength of the subsequent development of situation.
You are repeatedly saying these things. We are still yet to see where is the qualification. Where is the requisite qualification? Which rule regulation specifies the qualification? That is one aspect of the matter. The other thing is, if the recruitment process contemplates recruitment through a competitive examination, then whether those who are not as fortunate as you, whether they can be, that is another aspect. We'll have to see.
Advertisement was there. Advertisement, there is an opportunity to apply.
What opportunity, sir? This walk-in interview business I'm seeing here only. We don't know, at least speaking for myself, I don't know how things are.
Kindly, then
Walk-in interview just by face, looking at the face, you will make a selection. And those who are not so fortunate, who may not look so good, they will stay outside. Sitting this side, we have to see these things also. We understand your submission. We appreciate your submission. What kind of process? First walk-in interview, then you, and where is the permanency, when the permanency was conferred?
But we are working on the basis of extension order.
No, that benefit of continuance till 60 years.
60, yeah, yes, yes, which is at page 139. Kindly see.
Yes.
139.
State there must be some procedure. Necessary disputes.
Point number B, Roman 9.
You have been regularized practically. What remains? Then what remains?
Not the regulation, my lord. This is a continuation of service as contractual professor.
You have been given a higher pay, you have been given a.
And what was the view of the learned tribunal? Just
Tribunal-
observe them. Immediately observe them.
Terminal benefit, you have been given a continuance till 60 years.
But the status with the status of contractual.
And the rule under which the appointment is to be made is kept on the shelf. What kind of appointment you are doing? Yes, Mr. Mukherjee.
The recruitment rules in.
The recruitment rule is kept on the shelf.
No.
Yes, it appears so.
When after the Umadevi judgment, when the circular which was issued by the government, after the judgment of Umadevi 2006.
After judgment of?
Umadevi's case in 2006, when the state government can regularize, provided they complete 10-year service on 1st April 2006. They were appointed in 2009 or 8. That means what they cannot in 2000.
They were appointed after the bar was imposed.
Bar.
I have seen in one of the cases, they have said any appointment made after this will not be considered. So they are after the cut-off date.
Cut-off date.
Then why you are continuing for it? Why you have conferred this permanence on 26?
No, permanent, but they will be allowed to work as a contractually up to the age of 60 years, provided there is no any other report or any other misconduct.
Even if they are regular, they will be subject to any
Yes,
misconduct.
normal,
The big
it is
deal.
normal rule.
It is not
But-
that once they become permanent, they can commit a
No,
misconduct.
no,
and
no,
still
no,
they
no,
will work.
not really. That 60 years we have given an advantage to them, and nobody has challenged this circular.
Not
They have
required.
accepted it.
Not required.
They have accepted it.
Who is something beneficial? Why should they challenge? They want more. You give them 5, they want 10. Why they should challenge 5?
And after the recruitment rules was framed by the government, the selection process was started by the PSC. Some of them appeared, some of them did not appear.
Oh, they have participated?
No,
Yes.
no,
Some of them have participated. There are two matters.
No, there are 4 petitioners.
No, no, another matter is here.
There are 2 cases.
What happened? Page 172. Kindly see the recruitment rules. 172. Recruitment rules.
Oh, recruitment rule is there.
The 2012 recruitment rules. Page 172. Kindly see. Frame number 309.
advertisement. মনে দেখো তো এটা advertisement বলো। 37 এর মারফত কোয়ালিফিকেশন ফার্স্ট ক্লাস ব্যাচেলর কত দেখো বলো তো
Advertisement has already been published. (183). They choose not to participate.
I compared the qualification part from the rule and advertisement.
This will not apply. We are talking of something which took place in 2008-9. This is of 12. Your qualification cannot be seen with reference to this rule.
এই যে রুলটা
করছে কিনা দেখো তো, কোনো রিপিট করছে কিনা দেখো তো। না 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 করছে না।
If they did not participate, if that is your case, why did you continue after this exercise?
As soon as the term is, as soon as the person is selected by the PSC, the here appointment will be terminated.
Where is that?
Can you see the language in the appointment?
Forget about appointment. You have given them continuance till 60 years.
No, no.
You have continued their engagement till 60 years. Forget about appointment. Where is your opposition? Which page?
opposition is at page
152.
151 onwards.
Paragraph 6. Page 160.
160 কেন 156
Or sorry, 153.
হ্যাঁ হ্যাঁ 72.
Or I could for evaluate date with date. Identically. And politically. Upon taking contractual with 2008, 2009.
And where is that permanence, order of permanence?
Kindly see page 139. 139.
139.
9 of the
So after continuing them for 12, 13 years, then you make them permanent.
Everything has been considered by us. Everything has been considered.
It was passed under the
What
different
considered?
text.
Recorded bit, kind of.
They attach an order passed by the
Page 195.
Successfully 180. 180. That was delivered on December 2021.
That's correct. Subsequently, the judgment has come. And kindly see paragraph 7. What was the case?
Oh, you have continued because of an interim order of the court.
Petitioner is not the same. There, my lord, the writ petition is filed for seeking some benefit in terms of the notification of 2008 for regulation.
No, that notification was for regularization. And others were regularized under the benefit of that notification. So you said why you have left me out. They said why you have left me out. In that case, the court said no further appointment to be made.
And they have not fulfilled the parameter fixed.
And because there was a direction, there was no option but to continue. So they have continued you. It's not that they have continued you because they want to. You see paragraph 12 at page 195. You are also party to that writ petition.
No. We have not filed in, we are not, my lord, parties in those writ petition.
This is your first attempt.
First attempt.
No. We still we still have to see that the qualification.
Qualification partner.
You have shown that it is against sanction post.
Yes,
You have shown that it is continued. You have shown that there was an advertisement. But we don't know whether the rule existing in 2007, 8, 9 prescribed a qualification which was also possessed by you.
So otherwise they couldn't have been appointed because they were appointed as lecturers.
This is a contractual appointment. See, otherwise they could not have been appointed without commission, but they have been appointed.
No, initially, they have thought that it is a temporary nature. And this is the practice the state government is following in every department. That's why the Supreme Court has repeatedly said that you cannot continue like this.
That is all right. What we want to be clear is whether there was any rule existing in 2008 and 9 which specified any qualification.
That is apparent from the advertisement. If a Lordship kindly takes the trouble, my lord, to come to advertisement itself.
Yes.
Well, the nature of interview was walk-in interview, but the qualifications are prescribed.
It does not refer to any rule. Therefore, we are asking you. We have gone through that advertisement. There is a rule which has come into force sometime in 2012. That will not apply.
No, but Lordship will kindly come to that qualification. And if your lordship not compares, comparative rules গুলো বার কোনো ডিপার্টমেন্টে যদি থেকে থাকে, the consistently good academic record.
That is correct.
But
See,
that's the consistent rule followed by UGC guideline as well. That I can support your lordship in my contention. We are producing UGC guideline, but may not be today.
that's exactly what we are saying. Because to come within the four corners of the judgments which you rely upon, you will have to show that you were qualified as per the rules. You possess the requisite qualification also. Because you have not been selected as per the requisite recruitment process. So there is no presumption that every requisite was fulfilled.
The presumption is the other way, because the government couldn't have appointed underqualified persons to teach. This is not the
See, that we find it difficult to accept that because the government could not have appointed without going through the commission. They have done it.
The government will not have.
On the basis of a walk-in interview, they have appointed lecturers.
Yes. The lecturers appointment.
So therefore, the way the government has proceeded, we must see that at least they have ensured that they had the requisite qualification.
Therefore, not let them this the records are with them. This they are privileged. They should produce.
No, which the rule must have been notified. It is public knowledge. What is the rule in vogue at that time?
Give us some time to do research.
That is what we have been.
ICT. Yes, that's.
See, the parameters are laid down, but the requisite state governments may also issue rules in line following the guidelines. So either they adopt or go by the AICT or they make their own rules in accordance with the AICT. So which is that provision?
No, I have to not get myself ready on that. But this is a pertinent question which really did not come to our mind as well. But the basic question is whether their appointments were ultimately approved by AICT also. Therefore, the AICT couldn't have
approved by AICT.
Yes, yes.
Where is that?
Will kindly come to the page 136. 139.
In 2021.
I will find out the matter for revision of remuneration and other service conditions in respect of contractual and part-time staff in government and government-sponsored polytechnic engaged with concurrence of finance department and the service consideration of the government in technical education.
136 is your representation.
No, 139.
No, that is the state government. That's not AICT.
No. They refer to AICT Millot norms. Kindly come to Millot the enhancement remuneration, lecturer contractual, less than 10 years with qualification at par with the ICTE. Enhanced remuneration that was recommended. Then more than 10 years with the qualification at par ICTE. There was state government had
period of service is 10 years as per qualification of AICTE. But your entire period is about 15-16 years. Maybe you have acquired the qualification in the third year. We want to be clear that as on the date on which you were appointed by a walk-in interview.
I don't waste time. I will bring the ICT qualification.
Let us just see it and
relevant on that date.
Yes.
State government ICT follow korbi. State government ki UGC rule follow korte hobe.
The learned No, he is giving the citations. Yes. Separate order. You are appearing, he's going, he's appearing in both cases. Call 10, 20, or 20.
120?
Yes, who's appearing in 20? It is same. Common order equal. Same order. Common order.
PM item number 96.
My lord, I am appearing on behalf of the Appellant Life Insurance Corporation of India.
My lords, I'm appearing for the respondent number 3, Oriental Insurance. I'm sorry, your lordship, I'm suffering a tummy upset. That's the reason I'm appearing on the your lordship.
No problem. You are welcome to
The red petitioner
appear online.
Your lordship, on
Some matter regarding some claims.
Yes, some claims. On the part of the LIC, we have already complied of your lordship order only.
Some portion is left.
Just now, I received the instruction from the Life Insurance Corporation of India.
Give it to him.
Right. We have already disbursed, my lord, the gratuity, leave encashment, area salary pension, ESLI portion.
According to you, what remains?
Only NPS portion. Last column NPS portion, which is lying with the central government. That is under process, my lord.
And in fact, there are three aspects of
Where is that? Where have you stated?
The last line.
Last portion. NPS portion, last column.
Payment will be made by NPS Trust. It is under process. It is under process.
This will under process, my lord. They have already give the application form and we will under process, my lord.
How long do you think it will take?
I do not know it is lying with the central government. I will try.
No, are they parties here?
In fact, with the other two, they have already disbursed.
Already
There are three claimants over the money. Therefore, one third, they have already received the same. With regard to third, as per the court's direction, which they are paying now, this is only thing which is due and payable as per the admitted claim is concerned. Now, with regard, there are three aspects of the story. First, with regard to the admitted claim from the LIC. Second is that is also an admitted aspect, which is to be paid by the Orientals, which is in online. And third, with regard to the interest portion, which is being given by the trial bench. These are the three aspects. First,
the trial court has awarded interest also.
Interest also, which is kept on hold at this present moment.
Your lordship has already observed in your last order that it is only the interest amount which are the contesting.
So therefore, if that is accepted, because till now that order has not been challenged. So, yes.
Interest portion we have challenged.
The order where we have recorded that only interest is bone of contention is not disputed. So only interest is to be considered.
Yes.
That means all other payments are to be made.
Yes.
The other payment which is admitted, also there is some element which remains to be paid.
Right.
So before going on to the interest aspect, we asked you how long do you think it will take to make that payment?
NPS part, I will take instruction how long it will take time. My lord, it will be under the central government. That's why we have no control over them, my lord. That's
why are they not parties? Why did you not make them a party?
No. They were not required. This is within the ambit of the LIC itself. These are the retired dues of the person. They have already cleared the other two. With regard to me, the Shoma over here, and with regard to the mother, they have already cleared. This is not that this is the first time they are hitting the doors. And they are, with even being they are the party in the situation, they have already cleared the same. Therefore, with regard to NPS, this is only whatever that time will take.
All the time, long submissions are not required to be made. In every case, a long submission is not required to be made. We are asking a simple question. There is an element remaining to be paid. which is not in dispute.
Which is not in dispute.
They say some time is required. We are thinking how to expedite that. We are asking you why they are not parties. You are making a submission.
No, difficulty is there part from the LIC itself. Lordship, kindly have a look.
Payment will be made by NPS Trust. Who is NPS Trust?
NPS Trust will be paying to them. Thereafter, I will be getting.
So therefore, it is not for them. Then they, unless they receive, how they can pay? That is the issue.
If your Lordship do directs, we can.
Direct who? We are asking you repeatedly why they are not parties.
This is their appeal.
No, no, you have filed a supplementary affidavit, no?
No. Supplementary affidavit, we have filed impleading the son. The son is over here and he has got a portion of the fund.
Why are you saying history?
Fine.
Why are you going into history and making elaborate submissions? We are repeatedly asking you how to expedite the payment. Why they are not parties?
Lordship directs me, whatever conducive on our part to be done.
Unless they are parties, how we can direct? You tell us. Simple thing, you need not make. That's why we are saying at the moment, when we come to the interest part, we'll see what is to be done.
Another aspect.
That's another aspect of the matter. We have already recorded. Our anxiety was that let the admitted dues be paid. Then we'll see about the interest.
Then NPS is required to be made a party out.
So make them a party. You make them a party. You are the appellant.
Then he can make.
You can make them.
Supplementary affidavit.
No, that's an addition of party.
All right, you make them party. Yes, there is no dispute that an element which remains to be paid.
Another aspect is left. This is with regard to the Oriental who is online. Now, there is a 50 lakhs claim with regard to the Oriental, which is also a part of this retiral dues. And they have already forwarded the same, but this is also kept pending.
Forwarded it to?
Forwarded it to the Oriental for such payment.
Yes.
Kindly ask.
Your Lordship, may I submit? Your Lordship, we were not made a party in the original writ petition. Through CAN 2, we have been made a party in this appeal. There is no whisper about us in the order passed in the writ petition, number one, Your Lordship. And number two, Your Lordship, if I can submit, the payment was not done because LIC breached one of the clauses in the agreement.
All right, so that is not an admitted due. We will see that.
That is also an admitted due. Lordship kindly takes up their own annexure.
Make an application. Let this be completed.
No, kindly hear me for 1 minute. Thereafter, that is their own statement.
How can LIC admit a due of the Oriental?
This is the group insurance run by LIC itself.
But this has been paid. Amount paid.
The order dated by 28th August 2025. Oriental Insurance Company, we have filed supplementary affidavit.
Yes.
And the Honorable Division Bench has accepted my supplementary affidavit. My lord, kindly, if you also kindly travel to turn the August 28, 2025 order.
There was a difficulty for payment for which on 30th April, Lordship kindly have a look.
Please. Yes. Where is that order?
30th April.
My lord, order dated 30th April 2025, page 2, my lord. order dated 30th April 2025. First paragraph.
30th April order to the
Permit to treatment.
order. এখানে নষ্ট করলে
Yeah, so that's not an admitted claim.
No, if you,
I have already I have filed a supplementary evidence. Even
What you have submitted, sir, you please read at page 2 of the order past first paragraph. He further submits. Please read.
He further submits that Oriental Insurance Company is liable to disburse the group personal accident benefit of rupees 50 lakh only in terms of the memorandum of understanding and in the presence of the state company would be necessary for adjudication of the dispute.
Dispute. This is not an admitted position. So we'll consider that. First, let this NPS be done. Then we'll see.
for the adjudication of the total.
Returnable 2 weeks.
Kindly post a date, Malad.
There is no case undated from this court. In every case,
I
give
know,
it.
that's the policy of this.
Yes.
And at 2 p.m. let's have time.
All right. Yes.
Yes.
Weeks.
Then it can't be on third. We have got too many cases.
No, third. Except for third, it will be fourth.
Put it on third, 10th. Next week after that, 10th.
10th at 2 p.m.
10th February.
In the meantime, we expect that you will have filed the application for impleadment.
Great, sir. I'm with the since the lordship has already granted leave, I'm already. Only one prayer. Instead of 10th, kindly post it on 11th.
11th, it can't be. Then it will come on 16th or 17th.
It will roll.
16, 17.
It will roll down further. 10th would be better.
Because we take up the WPSC matters on Mondays and Tuesdays.
Oh, this is with regard to group 6.
Oh, then this can come.
It can come on 11th.
It can come on 11th.
Huh.
Huh? Monday and Tuesday.
Tuesday, till the 11th.
Tuesday is not 11th, sir. Please have a look at your calendar.
10th Tuesday.
10th is Tuesday.
9th.
9th, 10th, either.
9th, we can go for. 9th. 9th. Fine.
Or even 9th.
Just 10th I have got.
2 p.m.
2 p.m.
Deeply obliged.
Much obliged, my lords.
I am being misunderstood if you think I am angry. That is the way I speak in court. We want you to hear everything.
A poor
And
litigant
interact.
engaging a poor counsel with poor brain.
No comment. Yes.
Number 22. 2 p.m. madam.
As per my lord's direction, my lord, I have served a copy of the my lord, application, my lord, as well as other documents to the my lord, granted government pleader, my lord. No one appeared today also. Will allow me to is a change of landed advocate, my lord. That's it. 22.
That 155. 155.
Please for the state.
My lord, there is a change, my lord.
Oh.
That panel, my lord, I have already served to the learned government pleader.
Malik was appearing earlier.
Yes, my lord. My lord, I have already served the notice to the my lord, learned government pleader along with all documents, my lord. Copy of the writ, my lord. Their evidence, my reply all. May I communicate further, my lord? Any?
You are appearing.
Come for the state.
They have served a copy of everything. Why are you not here with the file?
Service করে দিয়েছি আমরা।
Yes, yes.
They have served it.
Please not appear on your.
So you are here with the file.
Please, sir. My, there for your lordship, I want to file a certificate.
Opposition is filed already.
Lordship, they have filed already.
How many times you will file an affidavit now?
We shall file by sharing to you.
Affidavit, reply, all filed.
আমরা রিপ্লাই ফাইল দিয়ে দিয়েছি তো আপনাদের কাছে আমরা এফিডেভিট রিপ্লাই দিয়ে দিয়েছি
Therefore, we asked you whether you have the file or not. We asked you at the beginning.
There are two other matters, similar matters, there is application file, but I just okay. But kindly
Not today, it will come on Monday. Mr. So-and-so appears, please.
একটা করে কপি দিয়ে দিয়ে দিচ্ছি আমি টিভিতে সার্ভিস করেছি হ্যাঁ বুঝেছি ওরা ফাইলিং না নতুন ভাবে দিয়েছি আবার
Item 23. Well, item 23 wrongly appeared in the list. Well, it's already been disposed of. Wrongly it appeared. Well, it may happen at 21.
Where is the disposal order?
One copy, my lord, it's 22nd of July.
Where is the file?
ফাইল আছে এখানে 139 wrongly appeared.
I may be expecting only one copy, my lord. And in terms of a lordship's order, my lord, they have also released the petition.
Very well, nothing is required to be done, just the list. I think the file has also not come. Perhaps they've only put it on the list.
Wrongly it might happen.
Already disposed of.
Already disposed of, and in terms of a lordship order, they have released it.
Item 24.
Malad, Mr. Shogoto Mitra is appearing for the appellant, Malad. Malad, he has not, due to some personal difficulty, has not come to court today, Malad. I'm only praying for not today, Malad. This is regarding Malad, Rule 14, Malad, deemed suspension, Malad. The petitioner has not got the gratuity, Malad. So, Lordship, only 1 day accommodation I'm seeking, Malad.
Yeah.
Suspension order.
Yes.
Your Lordship, only 1 day accommodation I'm seeking, Your Lordship. Due to personal difficulty, Mr. Mitra is not here. On earlier occasion, Your Lordship, in Sudhir Chandra Nondi and Krishna Chatterjee, Your Lordship has passed similar order, Your Lordship, as same footing. The matter is under the same footing, my Lord. So, Lordship, on the next occasion, on the next particular day, my Lord, Mr. Mitra will do the matter, my Lord. I'm only praying for not today, my Lord.
What order we have passed in those cases?
My Lord, Rule 14, my Lord, suspension, my Lord. Sudhir Chandra Nondi, my Lord, passed by your Lordship.
It is passed by this bench.
Just 2 months ago, your Lordship. Your Lordship. The Lordship, I have sent 2 copies, your Lordship.
So your claim for gratuity is pending.
Gratuity, only gratuity, my Lord. I'm getting subsistence allowance, my Lord. Only gratuity is, my Lord.
Subsistence allowance.
My Lord, the interim allowance, my Lord. What?
Your suspension was revoked in 2009. Why
Mal-
will you get
mal-
subsistence allowance? You are getting interim allowance under the DCRB because criminal proceeding is pending. In lieu of pension, you are getting 1/3 interim allowance. You are appearing for? Who is for the state? Who has to release gratuity? You or the state? State.
State.
Who was appearing for the state?
My Lord, I'll intimate, my Lord, if your Lordship kindly keeps the matter tomorrow, my Lord, I'll intimate state.
Opposition has been filed.
My Lord, one opposition, my Lord, supplementary affidavit has been filed. No opposition has been
Why you have filed the supplementary? For what? For what have you filed the supplementary?
My Lord, since the FIR was not there, my Lord, as I remember, my Lord, that's why your
The
Lordship.
entire complaint was not on record.
My Lord, my Lord, my Lord.
One page was only given.
Yes, yes, my Lord.
Now we remember.
So your Lord, yes, my Lord, your Lordship. The charge sheet and the FIR, my Lord.
There will be PCRB. PCRB. Negative, tell. Railway. Yes.
That state is here.
Yes.
Led by Mr. J.R. Day, Jawaharlal Nehru. Day. I am praying for an accommodation.
Why, madam? Well, here.
I am led by Mr. Jawaharlal Nehru. Day.
So if only issue of gratuity remains, then what is to be done then? What has to be argued now?
Malad, as your lordship knows, Malad, Mr. Mitra has done the matter, Malad. So, lordship, I'm only praying for 1 day accommodation. Your lordship, Mr. Mitra will come and do the matter tomorrow, Malad. I know your lordship has decided earlier also, but
Therefore, we are saying you are relying on that judgment. We have
Malad.
The same bench has passed the judgment.
Malad, but Malad, only 1 day accommodation. Since Malad, the senior has done the matter, Malad, I'll not.
Not today.
Deeply obliged.
Not today means Monday. You have got sufficient time. Yes. Put this in that file. Put it in that file.
125. Item number 25. I am appearing on behalf of the petitioner. Affidavit of service matter kept. Yeah.
Yes.
I believe my lord gone through the order. My lord, before that, my lord, the original application is annexed with my writ petition, page number 96 onwards. My lord, kindly turn page number 35, my lord. That is
So he will come, don't worry, yes.
my lord, kindly turn page number 35, my lord. I made an email to the authority, my lord.
No, we'll see everything. First, if we have understood correctly, your case is that the answer provided for 41C is not correct.
There is two option is correct, not correct. That is
Answer provided for 41C in the answer key is not correct.
probably, my lord, two answer is correct.
No. Your case is that the answer key which provides the answer for 41C is not correct. Because answer of 41 is there are two options.
Yes.
Whereas the answer key provides only one. So answer key is incorrect. So we were correct in assessing your case. Your case is that the answer key is incorrect. Because the answer key is incorrect and because there was two option, I did not answer. There is a rule that if I have not answered and the answer is not correct in the key, then mark is to be awarded. So I award that marks. Where is the finding that the answer key is wrong? Where is that finding?
That is not there, my lord. That's why I.
So that is your assessment.
My lord, I made a representation because of that. Yes.
We'll hear anything we are trying to understand. So that is your assessment.
I made my assessment before the publication of result, and in this
Whenever before at the time of reading you made, but it is your case that the answer key does not provide the correct answer because two options are correct in 41C. So based on your assessment, a direction should be issued for evaluating everything.
that is not my case, my lord. I made my case in other way, my lord.
Yes.
Other way around, my lord. Kindly turn, my lord, page number 26. 26 of that instruction is there, my lord.
Yes.
Para 6 says, my lord,
yes,
if more than one circle is enclosed for a particular answer in OMR answer sheet of part 1, it will be
Sir,
treated as
all this will be to your prejudice if that answer key is wrong.
There is, my lord, I stand corrected, my lord. It myself, my stand is that in that particular question, there is two answer is right. Option B is not wrong. Option B is one of the option, along with option D also. In para 17, I specifically stated when there is
So
two
where is
option-
the variance between what you are saying and what we are saying? We are saying exactly the same thing.
my lord,
According to you, there are two correct answers.
Yes.
Therefore, there was no question of marking
Yes.
in the examination
Yes, my lord.
by the
What-
examiner. But according to them, there is only one answer. That answer key is wrong.
Yes, my lord. Half true. Half true is
No,
more
it is not. It
dangerous.
is full true. It is full true. Because answer key cannot be right and both answers cannot be right.
My lord,
Both cannot stand together.
my lord,
So either answer key is wrong or your assessment that there are two correct answers, that is wrong. Both
Malad-
cannot be correct.
my lord, if we go through the my lord, question, it will be give the
So
more
therefore,
correct picture.
whether based on a candidate's assessment, a court is to direct for evaluation.
I am not saying so.
That is precisely your case.
My lord, that is not my case. I put my case, my lord.
That
My
is
case
precisely
that
your case.
my case is that, my lord, how
And if that is the question, then why after more than 1 year you have sent a legal notice?
my lord, before that, that's my case, my lord. Why what they did and what I did, my lord, and whether I was sit tight about my matter or not, my lord, canvass before this court.
Please, yes, show us.
Kindly turn, my lord, page number 35.
Yes.
That is my one of that is email sent to the authority. What is the email? 4-line email. I just read it, my lord. There was a question in final exam. That question within bracket question number 41. In communication system, repeaters are used to. The appropriate answer of such question is to increase the range of system. But there is also an appropriate answer of this question: reduce attenuation of transmitted signal. This answer is also appropriate. Therefore, all the candidates should have marks of such confusing question. Because of that, why I say so, in the date of email is very important. 17 July 2022. When exam hold, which is annexed with my page number 111, 21st November 2021. And the result, page number 150.
So you have lodged this complaint about 9 months after the exam.
Because of that, my lord, their results are not published. Yes.
Maybe because.
Yes.
Whatever it may be the cause, you have lodged this complaint after 9 months.
Yes. When the result is published, page number 93.
Yes. What is the date?
20 July 2023.
So immediately 20th,
23. After my email,
yes,
they almost, my lord, because that is in the year 2022. That is result published in the year 2023.
Where is the result at which page?
Page number 93.
93? Yes.
My marks is entry number 9 is mine, Shantanu Mondal. I got 53.17, and the last selected candidate, page number 95, in my category, 53.58. So
Yes.
0.47 is the differences. Malad, what they did, Malad, kindly turn page number 90. Page number 89 is my OMR sheet, and page number 90, because that OMR sheet I got subsequently making the RTI application. Page number 90 is the answer key, and page number 91, kindly see the asterisk portion of the bottom. Malad, got it, Malad, in the bottom?
That is accepted. Why you are looking
Malad,
at
Malad, my question is, Malad, because of that, Malad, in 5
you want to
questions,
show us everything. We are asking you to show the bone of contention.
a bone of contention.
There is only one thing in
Malad,
your
my
OA.
bone of
There is
contention
only
there.
one question which you are aggrieved by in your OA. You go through the entire pleading of your OA. Your dispute is only for 41.
Yes, Malad.
Nothing
Bone of-
else.
Yes.
According to you, 41 has 2 correct options. Therefore, you have not marked it. Whereas the answer key gives only 1. Therefore, everyone should be given 1 mark.
Yes. And they
Based
given-
on your assessment. Yes.
I just read one line, just one
Yes.
line. Page number 91, the bottom portion.
Yes.
Asterisk 1, asterisk 2, asterisk 3, asterisk 4, and asterisk 5. Correct option has not been given. All will get marks even if not attempted.
Correct.
In 5 question, that is question number 57 and question number 50.
That is
they
not
given.
in dispute. There is no dispute about
My
this.
bone of contention.
So
is
you
that-
say, therefore, this is wrong. Give me 1 mark for this
No,
also.
no. With greatest of respect, my lord, my bone of contention is that, my lord, when I made a representation, because in respect of that 5 question, the authority made the mistake. It is evident regarding that 5 question. If how they assessed it, because the candidate, they made the complaint. I also made the complaint. I want to know, my lord, whether how they adjust that complaint.
That is nothing about that in your OA.
My lord,
there is no such assertion in your OA. Go through your OA.
Yes. I go
There
to
is
my
nothing.
lord, but
You cannot enlarge in a writ.
My lord,
You have to
I am
confine to the OA.
not enlarging my grip.
You have to confine to your OA.
My lord, with greatest of respect, I am not enlarging it.
You are,
My
sir.
lord, I am not the expert. But the point is that, my lord, when I made a complaint,
All right,
an Article 12 authority,
all right, so that is
when
one
they
submission.
accepted that,
All right,
in
then
other question, they made the
Then why
mistake.
did they not look into this?
Yes, or they might looking that.
All right.
Because how they assessed my representation, whether they assessed it or not, they ought to make before this court, because how they made this conclusion regarding that 5 questions.
All right. What else? That is one submission. What else?
That is the only submission I could made it, because in the interim
That
stage,
is not your case. That is where is the question of interim is final hearing.
The second thing is that, my lord,
Yes.
I specifically pleaded, my lord, that regarding these 2 answer key, because 2 answer is right according to me, and in support of my contention, my lord, I annexed several books, my lord, with my petition, my lord. My second prayer before this court, my lord, consideration of that particular, my lord, expert opinion, I could say, because of that books contains that expert opinion, but kindly constitute a independent expert body. So, and there are several instances in our court itself, my lord, constitute an expert body, whatever, my lords want, this court want, constitute an expert committee, my lord, and he will assess that regarding question number 41, whether my contention is right or PSC's contention, health recruitment, police recruitment board contention is right. Because I made a representation, they, in respect of other question, they assessed it. Whether they assess this question number 41 or not, number one. Number two, if they assessed, how they assessed, that is never communicated.
That is never raised.
Yes, madam.
Show from your way where you have raised this.
I made this email.
Please show from your way where you have alleged that they have not considered your mistake, they have not said.
Kindly take page number 115, which is annexed with my OA, my lord. I made this representation and specific page number 115, my lord.
Yes.
For awarding 1 marks towards the wrong answer key and to issue letter of appointment.
You are straight away asking for marks. That is not your case. That why it has not been considered, why rectification has not been done. That's not your case, sir. You say it is wrong, give me 1 marks.
Yes,
that is all.
My lord, with greatest
There is
of
nothing
respect,
else in the way.
with the greatest of respect, when I made a representation, my lord, the natural justice
That you have submitted. That you have submitted. We have noted that.
My lord, the natural justice demands, my lord, they ought to, my lord, give an opportunity of hearing. My lord, they might accept it, they might reject it. In other case, my lord, in contrary, regarding 5 questions, my lord, they accept their mistake.
And they accept their mistake or they accept an allegation made by candidate.
Yes.
That is the difference.
But
whether they accept their own mistake or they are looking at a candidate's complaint.
yes, my lord, that ought
There
to,
is no candidate's complaint.
my lord, they ought to,
That
my lord,
fact is missing.
my lord, how could I know? My lord, with greatest
You
of
don't
respect,
know.
my lord, with greatest of respect, when I made a
Correct.
complaint,
You
my lord,
will know why we are telling you how you will know. Because there is a particular recruitment process where they give an opportunity for objections. In such cases, the candidate's objections are to be considered. Here, there is no such opportunity.
there is no such written, at least.
Correct. So, therefore, there is no question of this correction being made on any candidate's allegation. It has been done by the board in its own wisdom, as per its own expert opinion. It is not that other candidates has been considered and yours has not been considered. If there is an opportunity for objection, then only this can be submitted. Otherwise, how you can say?
May I read the original applications, the specific page number 101, that against such high-handed action, depriving the applicant from the selection process for recruitment to the post of wireless operator, your applicant made several representations before the respondent, but the same has no effect. So I made that representation, my lord. When my lord, I made a representation and specific representation, my lord, either they, if their own volition, I accept my lord contention is that, my lord, yes, in their own volition, they accept their mistake. My lord, if I made a representation regarding a mistake, my lord, whether they might not acted upon it. My respectful submission is that, my lord, after making that representation and repeated representation, email, thereafter, my lord, page number 115, representation, my lord, if they might not accept my contention. When they accept that, they made a mistake in their own volition, their own volition. But when they accept that they made a mistake, my point is that, my lord, that might be in own volition, there might be in pursuance of the candidate representation. Reason is not known to me. But the point is that the end result is that they accept that they made a mistake. When they accept that they made a mistake, that means that mistake might be not in regard of question number 5 question, it might be question 6 or 7. So when I made a representation, my respectful submission is that, my lord, they ought to consider that representation. They might reject it.
Sufficient times you have repeated. The same submission you have repeated sufficient
My lord,
times.
that's my case. That's why, my lord.
So saying it 10 times does not make it better. Anything else we are waiting for you to submit if there is anything else. This you have submitted sufficient times. Your submission, if we have followed by now, that when you have made an application, they were required to do something, they have not done it. And because that answer is wrong, 1 mark should be awarded. Yes.
That's
What
my-
else?
That's my case, and in similar circumstances, my lord, this court, my lord, my lord, this court as well as, my lord, the apex court also, my lord, bunch of, my lord,
Don't give one copy.
the judgment. আরেকটা আছে copy আছে? No, reported.
Yes.
Of judgment. Wrong answer. Compilation of judgment, my lord.
Yes, give us the paragraph, which judgment you are relying upon.
My lord, in our high court, my lord, start from our high court.
Whichever, and anyway,
Yes, yes, my lord, it's the page number 103.
Yes.
Coordinate bench, my lord.
Yes.
My lord, in that matter, because my lord, it says that two condition might be there. One is that, my lord, there is a specific rule that the candidate make a representation and thereafter the authority acted upon that. And the second thing is that there is no such option. In our high court, my lord, in regarding TET 2014, my lord, the same thing happened. There was no such option that the candidate will make a representation or make a communication.
You are referring to MAT,
Pratibha Mandal, my lord.
MAT 917.
Page number 31.
31.
103 is the next one. Page number 31. Honorable Justice Subhrata Talukdar and Honorable Justice Supratim Bhattacharya.
31.
1594.
1594. Yes. Which paragraph?
There is no such thing.
Which page?
Paragraph is not mentioned, my lord, here. Start from page number 84.
84.
Yes, sir. It's a longish cause title. No paragraph is mentioned. In this case, my lord, in nutshell, I place the case, my lord. A nutshell case was that, my lord, in TET 2014, there is a 6 wrong answer key in the instant of the petitioner, my lord. In JGB series, my lord. They made the representation as well as, my lord, they filed a writ petition, my lord. Initially, the court, my lord, constitute a expert board. একটাকে বলি thereafter TET 2022. The political. কোনটা? না, single bench, division bench, single bench করা যায়। And the
Yes.
Kindly turn page, I vote on page number 103, my lord. That is regarding, my lord, because of that fallen from this court, my lord, regarding Ran Vijay, my lord, in this matter, my lord. Considering the Ran Vijay, my lord, this court in regarding TET 2022, my lord, pass a judgment which is annexed with this bunch, my lord, page number 103. It start from page number 103, my lord. The relevant portion, page number 106. And Ranvijay is considered, my lord, in this matter, my lord. And the Ranvijay is quoted in page number 108.
Yes.
That's my submission, my lord. Meaning that, my lord, usually, my lord, court can step in the shoes of the expert, my lord. If I raise a question that there is a two possible answer, and when the authority accept that there are errors.
The other judgments?
For the timing, but it is considered others judgment also, my lord, because which I annexed, my lord, the results and all that is considered. Kanpur University, that is considered in the.
So basically, we have to see the two judgments of this court.
My lord, that's my respectful submission.
No, therefore we are asking you.
That's my respectful submission, because because of that, my lord, in TET 2014 and TET 2022, there was no such option that the candidate made a representation or the authority acted upon that representation. But the court appointed expert, my lord. That's my respectful. This court appointed expert, my lord, and it is upheld by the coordinate bench. That's my respectful submission. Is that, my lord, court usually not step
So
in the
both these matters are arising out of the same recruitment process.
No, both separate. The TET 2014 is a separate examination, and TET 2022 is a separate examination. And ultimately, the expert
The
opinion
judgment of His Lordship Justice Tandon is about 2014.
That is 2022.
And this one is of 2014.
That is Pratibha Mandal is 2014. And in respect of both, my lord, the expert hold that there is a wrong answer key. And this court, my lord, hold it, my lord, single bench as well as the division bench, my lord. And in the TET 2022, my lord, one wrong.
And in this judgment in MAT 1594.
Yes, my lord. In respect of that, my lord, several persons got appointment.
Whether Ranvijay has been considered?
No, my lord. MAT 1594 is Ranvijay is not considered, but the subsequent Honorable Justice Harishchandran passed that order. That in that judgment, my lord, Ranvijay is considered.
So he has considered then what he has said, that it is not the correct legal position.
Not said that, my lord. Court can, my lord, appoint.
Where is that?
But in this state 2022, my lord, court appoint, my lord.
Sir, where it has held, considering Ranvijay, that this can be done. Just show that line.
My lord, that line is, my respectful submission is that, my lord, when Ranvijay says, what a mess, my lord will remember that it is usual legal position is that, my lord.
Not usual, that is the binding legal position which has been considered by the coordinate bench also.
Yes.
It has not gone against that judgment.
I am also not on that, my lord.
You say that in exceptional case it can be done. Where does that judgment say so? Show from that judgment. You are relying on the judgment,
yes, my lord.
and you are making a submission. So to support this submission, which portion of that
My
judgment?
lord, may I read? May I read, my lord?
Which portion? Come to the
Page number
relevant.
106, my lord.
Sir, don't read the entire thing. Where is that relevant?
I am not saying that Ranvijay is altered by the coordinate bench. My respectful submission is that because it is binding. It is a apex court judgment. It is. I can't say this. It is.
Ranvijay has considered all the earlier judgments. Kanpur University, everything has been considered.
Yes, my respectful submission is that when I made a representation, I am on
Please
that.
don't repeat that. Please don't repeat that. Sufficient number of times you have said, don't keep saying the same thing. Now we are on the judgment. We are on the judgment. How this judgment supports your contention? Which paragraph?
First paragraph itself, page number 106.
First paragraph is not a
When
finding.
Situation has arisen in
First paragraph is not a finding. This is just an observation.
Observation how this case is cropped up.
Yes.
My lord, when the coordinate bench, my respectful submission is that, my lord, coordinate bench, my lord, upheld that position that a expert can appoint.
No. Where is that? Where is that? Show from the judgment where it says that it can be appointed by the court.
In the date 2022.
Sir, we are asking you about His Lordship Justice Tandon's judgment, because that is the judgment which has considered Ranvijay Singh's judgment. The earlier judgment has not considered Ranvijay Singh. Where it says that it can be done.
My lord, may I read, my lord, page number 109, because that is not paragraph.
Please.
The law as it stands unequivocally runs to the effect that point touching upon the academic field should be left to the academician, and the High Court should not interfere in a mechanical manner. Simply, some of the aspiring candidate or aspiring examinee has approached the court, flagging an issue on the wrong framing of the question or wrong choice in the answer keys. Equally, we do not find any absolute embargo, that is, my lord, most absolute embargo in the aforesaid decision in exercising their judicial review in this regard, as we think that the real purpose is to bring correctness in the question and the answer as the wrong, if allowed to sustain, would clearly affect the academic career. Though we feel that the single bench ought not to have ventured deep into the
Correct. This is the finding of the court.
Yes.
That the single judge should not have done it in view of the law. That is why we asked you. Now you come to the other paragraph at page 8.
Yes.
Bottom paragraph. What His Lordship has said.
108.
108. Sorry, 110.
Yes,
The Vishwa Bharati has no.
Vishwa Bharati has no role to play in the curriculum, not the textbooks so prescribed or taught at the different medium by the respective state, and therefore subverting the views and the opinion of the independent committee to the Vishwa Bharati University to act as an apex institution shall percolate a wrong signal. Put an end to emphasis as the large number of litigation are pouring in the dockets of this.
Now, this next line is very important. We feel
that the moment the court has undertaken such exercise,
and very important, and the respondent authorities have implemented the order. In that circumstance, the court has passed the order because the respondents have implemented the order. It is a consent.
But
there is no dispute between the parties. All right. So therefore, 22 has not considered Ranvijay. Anything else? We have taken note. Heard learned advocate for the writ petitioner. You 2 minutes. Yes.
Page 94.
Yeah. Yes.
But the last part, one sentence. But before that, the secretary, paragraph secretary also is except to ever ask for the exhibit A. These orders shall not, however, affect steps taken so far by the board or committee in the process of being taken by the board in respect of K 2014 figure K 2014 of the subject matter. Now, here's what happened. Here was having so far the mother recruitment board is considered these instructions which I received from the recruitment board, the response number 2 here is, you could also kindly have a look, my lord, how it can be, my lord, unsettled when everything has already been settled. Notification date, the advertisement date 13 February 21, application starting 22nd February 21, last date, they also kindly come to the date of preliminary written examination 24/11/2021, number of exam center, then another primary written examination date in 2022, final written examination date on 15 June 2022, then my lord interview venue, then date of commencement of interview at the bottom almost 28th of March 2023, last date of interview 29th of March 2023, final results published 20th July 2023, number of candidates provisionally selected and interview completed. So after this,
No, his case is that when he has made application, why you have not considered? You know, you are state.
yeah,
Who is representing the recruiting body?
the recruitment body was somebody else.
Where is? Who is appearing?
One. No. No. The order.
Yes, Mr. Shamim Ahmad, who is appearing for the
Well,
recruiting?
at least from the order, it is not evident.
We are not finding anybody's name.
Yes, at least from the order, I am not finding.
In none of the order it is.
Three orders.
So perhaps notice has not been served on this. The We just want to record the submission in your presence. That is why we do it. We'll pass the order.
And another fact, my lord, I just missed it, my lord, because why he delayed, because of that, my lord, he got the OMR sheet and answer key in the year 2024, 2020.
Call the next.
That is all.
26.
Mm-hmm, 18. Yes.
My medical, my expenditure for medical treatment outside the state of West Bengal, that was rejected only on the ground that I have not taken any prior permission.
Approval has not been taken.
Page 56.
You got a copy of this?
Yes.
First page of the
And before going to the compilation, if your lordship kindly see for a moment my application for reimbursement, page 45, for a moment of my application, application, page 45. And what is the situation? My lord, that is
Remember, you said you had gone for a routine checkup.
routine checkup. Then, my lord, I faced cardiac attack. Then, got doctor advice immediate operation, and I admitted in
That we
hospital.
remember. Anything else you want to say?
No.
My lord takes up page 1 of the compilation, my lord. This is a scheme called the West Bengal Health Scheme 2008. Thereafter, if your lordship skips to page 16, my lord, of the compilation, my lord. It is an amendment that has taken place in the year 2010, my lord, 30th of July 2010, and clause 14, my lord. Page 16, clause 14, my lord, which specifies treatment in a hospital or institution outside the state, my lord. If your lordship turns page 17, my lord, clause 2, my lord, there's a mandatory provision, my lord. Prior approval of the secretary of the department shall be obtained before receiving medical attendance and treatment in these hospitals or institutions, my lord. Thereafter, my lord, if your lordship takes up page 18, my lord, it is a memorandum dated 5th of October 2009, my lord. And the relevant page is page 20, my lord, of this notification of 2009, my lord.
Which clause?
Page 20, man. Page 20, clause 7, madam. Page 20, clause 7, I'm relying upon, madam. Which clearly says for treatment of a government employee, government pensioner, and members of his or her family in a specialty hospital outside West Bengal, prior permission of secretary of the department is required, madam. Then, my lord, page 23, my lord, of the compiler. Page 23, my lord, it is a notification of the year 2018, my lord, 2018, my lord. It says, my lord, as per existing norms, government employee, pensioners, family pensioners are required to take permission from the West Bengal Health Scheme Authority of Finance Department for availing treatment outside West Bengal, my lord. And thereafter, my lord, page 24 of the compilation, my lord. It is a order of the year 2022, my lord. And it even facilitates for availing online options, my lord. That are page 24 of the compilation, my lord.
What at page 23, what are you referring?
But a prior permission, my lord. 23 is a notification, my lord. It is called that as per existing norms, government employees, pensioners, family pensioners are required to take permission from the West Bengal Health Scheme Authority of the Finance Department for availing treatment outside West Bengal.
Treatment is in which hospital? Apollo.
Fellow Hospital, Chennai.
Yes, after 23.
After 23, my lord, I want to rely upon page 24 of the which provides them online facility for seeking this permission, my lord. If your lordship takes up the second last paragraph of the notification, now, may I place it, my lord? Now, after careful consideration, the governor is pleased to implement online, my lord.
কোন আইটেমটা যেটা এটা 95 কাট অফ মার্কস নিয়েছি কাট অফ মার্কস তাই তো ড্রাফট অর্ডারটা করলি হ্যাঁ এটা তো ফাইনাল অর্ডার আপনারা দুইটা আছে
There is the medical attendant rules. We asked you to show the rules. You are giving a compilation of notification. Huh? Sir, what is the order? Please see. Paragraph 3, please read, sir. Various orders. We wanted to see the entire scheme of things. There is a medical attendant rules. Where is that medical? That is the basis. These all notifications are in addition or supplementing that rule. Where is the basic rule? We have asked you to come with it, all of it. Why are you coming piecemeal? See, we have had the opportunity of seeing similar medical attendant rules earlier. In all these rules, there is a residuary clause. It is never watertight because it is a question of life, maybe a question of life and death. So therefore, we asked you, where is the medical attendant rules? Whether there is any scope or not, according to that, we will decide the matter. You should have come with that. Despite the seven
This is my affidavit.
opposition has been filed already.
We have been served, my lord.
They say they have not been served with.
No, we have.
Oh, they are giving it.
No, we have been served.
We are filed.
And copy has also been served.
A reply